Thank you for joining today's Paget Law Group client training webinar. It's a complimentary client webinar titled Replevins, Issues and Challenges from a Multi-Jurisdictional Viewpoint. I'm Stephen Hurley, the Florida Supervising Attorney for PLG, and I'm also here with Mitch Berry, our Arkansas Supervising Attorney. The webinar is part of our complimentary training webinar series, which covers legal topics and issues important to clients working in the PLG footprint, which includes Florida, Georgia, Tennessee, Arkansas, Texas, and Ohio, as well as our national services for Replevins and bankruptcy. As clients, you can always share webinar registrations with your colleagues and other departments, as well as the recordings of our webinars, which are distributed to the registrants after the live presentation. You can always contact us with questions about these and other topics as well. As presenters, our contact information is listed at the end of the presentation material, so feel free to reach out. Before we begin, I want to remind everyone that your GoToWebinar control panel on your screen allows for an interactive Q&A throughout today's presentation. So simply just click on the questions icon in your GoToWebinar control panel and type in your question. At the end of the prepared remarks, we will address our questions and answer them live on today's recording. PLG has offices, and we may as well just get started. PLG has offices in Florida, Georgia, Arkansas, Tennessee, Texas, and Ohio, as we mentioned. But in addition to those, and more pertinent for today, PLG also has a national replevin and bankruptcy practice as well. So although today's presentation may discuss a little bit more about Arkansas and Florida compared to other states, have no fear if you don't have any or many loans in these two states, because PLG has a presence in all 50 states with knowledgeable and experienced attorneys and support staff throughout. So if you have any questions or files that need immediate attention, in which Mitch and myself are not licensed in that particular state, still let us know, and PLG can assist no matter what. And I'm going to pass the Replevin process part of the presentation over to Mitch Berry.
Good afternoon, everyone. We're glad to have you. My name is Mitch Berry. I am the supervising attorney at Paget Law Group for the state of Arkansas. And we're going to talk some about the Arkansas Replevin process today. I've been doing Replevins for mobile home servicers since about 2001 or so. So I've been doing this quite a while, and it's something we feel good about our ability to serve you. So let's start off with just the definition of a replevin, which is a possessory action to recover specific property. That's how the Arkansas Supreme Court has defined it. So the key word there is possessory. It's not an action to recover a money judgment, and it's not an action that is related to real estate or real property in any way. The one common issue or concern is who are the necessary parties to a replevin action, and it's anyone that's in actual possession or constructive possession of the collateral, which could be, any personal property like a car or a mobile home, or equipment, commercial equipment of some sort. So anyone that is in actual or constructive possession of that collateral and has an interest sufficient to establish possession for purposes of plaintiff's right to delivery of the collateral. Therefore, anybody that's in possession should be named as a defendant. So that could include the borrowers. It could include landlords, like in a mobile home park situation. It could, and often does, include heirs of the borrowers if the borrower is deceased. It could include tenants. And oftentimes, if we don't know exactly who has possession of the property, we name unknown occupants of the manufactured home. The venue for a replevin action in Arkansas is the circuit court where the property is physically located. Sometimes that is not clear. It can be right on a county line, or when you made the loan, when the loan was made, it was located in one county and is now located in a different county, or sometimes there's just a mistake on the paperwork about where the location of the home was or is. And so we sometimes have to correct that as we go along. The first legal action in the Replevin action is just like any other judicial action. It's filing of a complaint. In the case of a Replevin, it's called a complaint and affidavit for possession. We also file a notice of petition for order of delivery, and then we have summonses issued just like in any other judicial action. We've got to serve the complaint, notice, and summons just like any other lawsuit in Arkansas. Personal service is required. Posting is not sufficient. You may be familiar with quiet title actions or some other type of action where you can simply post the notice. But that is not sufficient here. You have to get personal service.
And that's one of the main differences. Sorry to cut you off, Mitch. That's one of the main differences in Florida, where I'm going to get to it a little bit later. But the statute, especially the order to show cause statute, which is key for Florida, it does allow you to post. So it's going to vary by state. So Arkansas, you can't. Florida and some others, you can.
That's nice. I wish we had access to that, Steve. So you can. There is a process called a warning order, which you might refer to as service by publication, that can be used in Replevin cases. The key to that is that you have to prove to the court that you have conducted diligent inquiry to find the identity and the location of the defendants. This has become a highly scrutinized issue in Arkansas over the last several years. So we try to avoid that if at all possible. Typically, if we're having to search that hard for a defendant, it means they aren't living in the home any longer or don't have possession of the collateral any longer and may not need to be an actual defendant in the Replevin action any longer. So we analyze that as we go through the lawsuit. In Arkansas, there's a 120-day deadline after filing of the complaint to get service on the defendants. The response time for the defendants is different in a Replevin than other judicial cases in Arkansas. They have 5 days to respond to the notice of petition for order of delivery, which is really the key timeline. The statute is very confusing. If you were to just pull the book out and look at it, there are actually 3 Replevin statutes that the legislature kind of stacked on top of each other. So even though you have that 5-day deadline, there's still also a 30-day deadline to answer the complaint. So if a defendant doesn't respond within 5 days of being served with the notice, we go ahead and send an order for delivery to the judge and ask the judge to enter that order for delivery. A lot of you would call that a writ of possession. In Arkansas, it's called an order for delivery. But if before the judge enters that order, there's an answer filed within the 30-day period, we go ahead and treat that as if it were a timely answer, and we follow our procedures for a contested case, which is our next topic is the procedures for those contested cases. Generally, if we get an answer, we will go down one of 2 routes, depending on the judge and depending on the county and the location of the property. We may just go ahead and get it set for a hearing. With some judges, we have found that that is the best way to go. So we'll just get it set for a hearing and ask our client to provide us a witness and have a hearing. Oftentimes, though, we try to avoid that if possible because our clients don't necessarily have a witness readily available to send to us. And so we'll try to avoid that by filing a motion for summary judgment. And like I say, some judges don't approve of the motion for summary judgment process in a Replevin case. But oftentimes we will file that and the defendant will not respond to the motion, and we can get a an order entered fairly quickly that way, if no response is filed. If a response is filed, we then get it set for a hearing. If there's a response, I'm sorry, do you have a question, Steve?
Yes, I actually wanted to talk a little bit about how Florida has very similar rules, but also differs a little bit. So as far as trials go, sometimes the judge will prefer to have a non-jury trial over an MSJ, similar to what Mitch was discussing in Arkansas. But Florida does have a favorable statute where if a witness cannot attend, or if it's a lightly contested file, maybe a pro se borrower is the one contesting it and the defenses aren't valid or they haven't filed any defenses, then what you can do in Florida is, pursuant to the statute, you can actually file ahead of time a certification of business records, which is very similar to a supporting affidavit for a motion for summary judgment, but it lays out all the necessary language authenticating the loan agreement, verifying that the notice of default was mailed out if one was necessary, verifying that the judgment figures and the payment history was accurate. So there is a way in Florida where you can actually have a non-jury trial without a witness attending. So that's very favorable for some of these Replevin actions where they may not have counsel on the other side, but the court prefers a trial over a summary judgment.
That's good, Steve. Thanks. With our motion for summary judgment process, sometimes we'll get a hearing set on the motion for summary judgment and avoid the necessity of a witness that way. And then we get a second bite at the apple and have an actual bench trial after that, and get a witness there if the court on the first time around indicated that he needed to hear the testimony of a witness, he or she needed to hear the testimony of a witness. So it's kind of depends on the county, depends on the judge. Some are more difficult than others, and we just kind of analyze that as we go. It can take, if we need a hearing, it can take several months to get that done, depending on the court. As you know, now it's more difficult to get a hearing date with the COVID issues. Some courts are still taking their sweet time about opening up. Others are going full speed ahead. Some courts are having Zoom hearings, which is nice. I've got one coming up soon where my witness is also going to be able to appear by Zoom, which is very new for us, and we're looking forward to it. Hopefully other courts in the state will adopt that same procedure soon. But we will need a witness, whether it's by Zoom or live in court, to do three things: authenticate the contract or the note and the certificate of title, just to say it is what we claim that it is, and then testify as to the breach of the contract or the failure to pay. So generally that will consist of questions like, when was the last payment made and how many months behind are they? What's the total amount of the debt? Did you make demand? Did you send a notice of acceleration? And all of those things that you're used to looking at or hearing about in a foreclosure context, we would also ask about in a Replevin context. If there's any defenses raised by the borrower, such as a common one that we hear is loss mitigation. Well, hey, I talked to the servicer and they told me that if I made a payment by X date, they weren't going to file this Replevin. And of course, we check with our client, and that is not at all the conversation that occurred. But that is basically the defense that the borrower is raising. In Arkansas, they're not really allowed to develop that defense extensively at the hearing. The burden of proof, the statute says, is prima facie evidence that the petitioner has the right to immediate possession of the property. And prima facie means, in the context of prima facie evidence, prima facie means just on its face. So without hearing any of the defenses to the evidence, if it is apparent on its face that the plaintiff, being the servicer, is entitled to possession of the property, the court should grant the order for delivery without hearing extensive defenses. On the next slide, I cite a case there, an Arkansas Supreme Court case that's pretty old, 1975, but it stated that extensive evidentiary development of defenses is not required, especially if they are alleged in conclusory fashion without specific facts and circumstances. Therefore, at most hearings, the judge will stick with those three items I listed on the prior slide: authenticating the contract, testifying as to the failure to pay, and well, really, it's those two things instead of those three things. Once we get the order for delivery, we send that over to the sheriff and ask the sheriff to serve it on the defendant or post it on the property. At this point, you've got the order for delivery in hand, which is what entitles you to possession of the property. And we ask the sheriff to either serve that on the occupants of the home or post it on the door of the home, giving those occupants 5 days to remove themselves and their belongings from the home. One of the things to keep in mind here is that must be done by the sheriff. It can't be done by a private process server. So sometimes it can take quite a while to get a sheriff to move that to the top of his or her list and go out and do that for us. But most sheriffs, we have a few counties that are difficult in Arkansas, but most of them are pretty good. After that's done and that 5 days expires, we are entitled to possession of the property. And generally, the best thing to do at that point is for our client, the servicer, and the sheriff to just get together and set a time to go out and conduct a move out, set a move out date, lockout date. And that's really, it's best for the servicer and the sheriff to just work together on that. The lawsuit at that point is technically still pending, and a lot of times a few months down the road we'll start getting letters or calls or emails from the judge's office saying, hey, this is still pending. Do you need what do we need to do to close this out? We try to keep those pending for 6 months. After it's been pending for 6 months, we'll typically dismiss the case at that point, because if you haven't acted on that order for delivery within those 6 months and gone to take possession of the home, then most sheriffs are going to treat that order as being stale, and they won't act on it any longer. They'll want a new order at that time. So it's important to keep that kind of informal deadline in mind as well. Once you get the order for delivery, the clock is really ticking on your time to go get physical possession of the property and make sure everyone else is locked out and move the home if it's on a mobile home lot or something like that. And that really concludes the Arkansas process. I think it is other states are quite a bit like it. Some states, I think Florida, like Steve's going to tell you, is more on the cutting edge and has some expedited procedures. So I'll let Steve go ahead with that.
Great. Absolutely. Yes, Florida does have some interesting procedures and some carve-outs for replevins compared to other cases. For the most part, the civil rules of procedure are intact and are the same. However, there are some statutes that are very friendly for lenders and lenders' timelines, and I'll get into that in a bit. The replevin actions, they're all governed by Chapter 78 of the Florida statutes. Statute begins with Section 78.01. It says essentially any personal property wrongfully detained may have a writ of replevin to recover said personal property. Now, wrongfully detained for most cases is when a borrower fails to make timely payments and defaults on their loan agreement, whether that's a mobile home, automobile, or other personal property. Florida statute 78.03 relates to jurisdiction, which essentially means which court is the action brought or can be brought. An action for Replevin must be brought in a court of competent jurisdiction based on the value of the property sought. So it's important that the amount that's important is not necessarily the unpaid balance, but rather the actual value of the property itself. And that will determine where you file, whether you file in county court, which is for goods that are valued less than $30,000. This is actually a change. Previously, it was $15,000, but that's been updated to $30,000 for county court filings. And then small claims court, which is within the county court jurisdiction, it's their own little carve out. If the goods are valued at less than $8,000, then you are to file in small claims court, which has its own particular set of rules. It involves mandatory mediations, pre-trial conferences right away. So it's a little different with small claims court. And of course, circuit court, if the goods are valued beyond $30,000, then you would file within circuit court. The next section, a relevant section of the statute, relates to venue. So that's where is the action brought. In other words, what county is the Replevin action filed in? Typically, when it relates to a mobile home, we're filing in the county in which the property is located. Mitch mentioned it. Sometimes it's not easily determined which county the mobile home resides on. It's on county lines. The mobile home's been moved. So there's a little bit of digging that you have to do before you file to make sure that you're filing in the proper jurisdiction. For personal property that can be moved more easily, like a car, then we look at some of the other two options, which are where the location of where the defendant resides and where the contract was executed, if you cannot determine exactly where the goods are located. But for the most part with mobile homes, you're filing where the mobile home is located. Okay, and the next section is the first legal requirements. So as you all, I'm sure, are aware, if you have any files in Florida for foreclosure actions, you have to actually verify the complaint. You have to sign under penalty of perjury that you verified the complaint and it's accurate for a foreclosure action. That's not the case with a Replevin action, even if it's for a mobile home where the borrowers reside. So that's a huge difference between Replevins and foreclosure. There's no need to verify the complaint beforehand. There are several requirements, though, for the complaint. It's pretty standard. We do make sure that we follow the statute to a T and we comply and we include all of this information. But essentially, it's a description of the claimed property. So for a mobile home, which is the bulk of the Replevins in our industry, or for automobiles, then we would include the make and model and the VIN numbers. We also include the estimated value of the goods, and that's important to determine the jurisdiction, whether we're filing in county, small claims, or in circuit court, and the location of the property to the best of our belief and knowledge, and a statement that the plaintiff is the owner of the goods, entitled to possession, and the goods are being wrongfully detained. Now, I mentioned it a little bit previously, but the wrongfully detained language sometimes scares off some people. But it really just means if for our circumstances, typically for most cases, if the borrower's in default and hasn't made payments, they are wrongfully detaining the property.
Steve, I failed to mention it in my presentation, but those are exactly the things we would allege in our complaint as well in Arkansas.
Yeah, it's very similar. I didn't necessarily harp on a lot of the things that Mitch already discussed, but very similar rules of procedure, first legal requirements, sheriffs with writs. The states have very similar rules. There's just nuances in each state, but the overarching rules are pretty similar across the board for all 50. But again, there are nuances, and you need to have a firm that can really take a look at how each state works and make sure that you are moving your files as efficiently as possible and taking advantage of some of those carve-outs and some of those nuances and unique statutes. So that's why it's important that PLG is located in all 50 states, so we're readily aware of all the requirements throughout. The next section is really important, and it's the order to show cause statute, and it's section 78.065. This is really unique to Florida. It offers sort of a fast track into the Replevin process. It allows the lender to obtain writs and pull the property prior to the entry of judgment, so you don't have to go forward with a motion for summary judgment or a default judgment, non-jury trial. You can actually go down this route, follow the statute to a T, and obtain writs of Replevin prior to entry of judgment and serve those writs. And without a judgment, the lender is entitled to pull the property pursuant to the statute. So it's a very, very unique and cutting edge statute that we essentially have it down to a science. We've been doing this for years. We have a very good relationship with sheriff's offices, which are really important, and with the courts to get everything executed. But essentially, I'm going to walk through the whole process. The complaint is filed, and pursuant to the statute, the court shall issue without a delay a pre-judgment order to show cause hearing. And how it works out is we will prepare the order to show cause pursuant to the statute and all the requirements and guidelines of the statute. We will upload that proposed order to show cause, or via physical mail, depending on the county and judge, to that court, and the judge will review the order to show cause and set a hearing date to be heard. And the hearing date, typically we ask for a hearing date 30 days or a little bit more outside of the execution from the court of the order to show cause, which will give us time to serve all the parties with the order. Number two, this order issued by the clerk shall state that it is directed to the defendant to show cause why the claimed property should not be taken from the possession of the defendant and delivered to the plaintiff. So initially, the burden is on the defendant to raise some sort of objection, file their own affidavits in opposition, file an answer with affirmative defenses to the complaint. It's on them to show why plaintiff should not be entitled to receive their writs. On the order, the date and time of the hearing, no sooner than 5 days prior to the parties being served with the order to show cause. Number four is really important. So it involves the service of process. And this relates back to what I talked about a little bit during Mitch's section, how in Florida you can post on the property. So as long as you make 2 attempts, no sooner than 6 hours apart, you can post the complaint and summons, and in our case, the order to show cause as well, simply by posting it to the door if you've made multiple attempts and you haven't been able to serve the borrowers. So that's different than some other jurisdictions and some other statutes. Going back to number 3, the order to show cause and the complaint pursuant to the statute needs to be served 5 days prior to the hearing, but we recommend serving well in advance of that. We do not want to allow the borrower to show up to the order to show cause hearing and say, I simply didn't have enough time. They only served me 5 or 6 days prior to the hearing. So from our standpoint, we recommend servicing the documents in the order to show cause and the complaint and summons more than 20 days to give them time to file a response if they need to. And we're still well within the statute's requirements. Although if the judge does execute an order to show cause and doesn't give you enough time, you always can try to proceed, because the statute does allow you to proceed if it's more than 5 days. However, we've noticed that judges are more lenient in either denying order to show causes or extending a delay on issuance of writs if they were served close to the hearing time. Okay, and failure to appear by the defendant shall serve as a waiver to be heard, and writs are typically issued afterwards. Okay, the next relevant section revolves around the actual hearing in the order to show cause. So the court looks at the pleadings and any opposition filed by the borrowers or any defendant. The court will also listen to any arguments made by the defendants at the order to show cause hearing. They do give a little bit more leniency to pro se borrowers, even though technically they probably shouldn't pursuant to the rules, but that's just how it works, where they give a little bit more leniency. But if the defendant's arguments are not sufficient, they don't raise any sufficient defenses, the court will issue the writs, which will then be sent to the sheriff, similar to Arkansas for service. It has to go to the sheriff, not a private process server, once you have the writ of replevin. And after this process and after the writs are served by the sheriff, typically within 48 or 24 hours in Florida. Mitch mentioned 5 days in Arkansas. It's a little bit of a tighter turnaround time in Florida. The lender can take control of the property after it's been served by the sheriff. Courts do sometimes delay issuance of writs if the borrowers need more time to move out. It's just going to vary given the circumstances. Also, it's important to note not every state has an order to show cause statute, but states may have other fast track methods or carve outs in their statute or nuanced rules to obtain writs in possession of the property. So at Paget Law Group, we ensure compliance in all 50 states, and we provide our clients with the options to move your files as efficiently as possible, and we utilize each state's rules and the law to our benefit to make sure that you are moving your files accordingly, because each and every one of your states are going to have different rules. Okay, and if for whatever reason the order to show cause is denied, maybe they hired counsel that raised appropriate defenses and the court didn't or felt that they've met their burden, then you would need to proceed with a final adjudication. Typically, it's a motion for summary judgment of replevin, a default judgment potentially. However, if an order to show cause is denied, it's typically because certain defenses were raised, so it's rare to get an order to show cause denied and then get a default judgment. However, if the court, sometimes there are a few judges that don't necessarily like the order to show cause process, there's a few holdouts, we can proceed with a default judgment if the borrower has not filed a response or not appeared in anything. We file a motion for default, and as soon as that's entered, we proceed with default judgment as quickly as possible. But the final summary judgment standard, it's the same, similar to foreclosure, and the standard to prevail is it does not exist a genuine issue of material fact, and the plaintiff is entitled to immediate issuance of writs. And similar rules of procedure where the defendant should file affidavits in opposition to the summary judgment and defenses as well. And if not, typically judgment is granted. Another option in order to proceed via judgment is the non-jury trials, the bench trials. If the case is at issue, the court may set it for trial. Some courts prefer to set a non-jury trial as opposed to motion for summary judgment or order to show cause. They're more rare in replevin actions than foreclosures, but we still see them quite a bit. And I mentioned the certification of business records statute in Florida does allow you to proceed without a witness given certain circumstances, and that certification essentially is an affidavit which establishes all your business records are true and accurate, and establishes the hearsay, establishes the statute that all of the documents are in order, the payment history, the judgment figures, the note, mortgage, and all of that, or the security instrument, not the mortgage, but the security instrument and all that. So very similar to the setup for a foreclosure action. However, if it's heavily contested and multiple defenses are raised, we do always recommend a live witness. It's cleaner It's easier to proceed in that manner, and certification of business records could potentially be thrown out by a savvy defense attorney. So if you're involved in a heavily contested case, it's just easier to go forward with a witness. Okay, my next subject is tax deed sales. A tax deed sale is the sale of a property at public auction for back taxes and fees associated with bringing the property to sale. And tax deed sales are governed by Florida Statute Section 197. And it's really important that you're really checking for any outstanding tax deed certificates and tax deed sales, because the mobile home may become part of the real property. And in the event of a tax deed sale, the mobile home may become part of the real property that's up for sale at the tax deed sale. So it's really a major issue if the owner of the mobile home is also the owner of the land, and the mobile home is permanently affixed and connected to the normal and usual utilities and affixed to the property and issued a real property series sticker tab. A mobile home that is not taxed as real property shall have a current license plate properly affixed. But if it is considered or permanently affixed and considered part of the property, tax deed reviews should be done on your mobile homes. Section 197.522 provides that the clerk of court shall notify by certified mail with return receipt requested the persons listed in the tax collector's statement pursuant to Section 197. The parties that are noticed are any legal title holder of the property, any lien holder of record who has a recorded lien against the property, and any mortgagee of record if the address appears on the recorded mortgage. The main issue for tax deed sales, they occur when the title holder has not recorded their new interest. So when the loan is transferred from one lender or servicer to another, if the new lender does not record their interest, then the notice of tax deed sale will go to the prior lender. Sometimes the prior lender does not forward that notice over to you, so the new lender may be unaware that the property is potentially up for a tax deed sale and has outstanding taxes owed. Therefore, we always recommend that the new lender always records their interest. And that leads to the next slide, how to protect your interest. Per case law, it's imperative that the lender records interest right away in order to protect their interest in obtaining the notice of the possibility of a tax deed sale. And it's imperative that the lender and subsequent assignee continue to update their interests and records in the official records to ensure that proper notice is provided. If you have not updated your interest and the loan has been transferred over to you, then you may be able to, or you may lose the property due to a tax deed sale. So it's so important that you protect your interest right away. And we've seen numerous properties lost at a tax deed sale for this reason. So I can't stress it enough. There are some potential defenses, but those have to be reviewed on a case-by-case basis. So it's really important to protect your interest at all costs. And the next slide relates to tax deed sale surpluses. So one final mechanism for recouping any loss that may have been the result of a forfeiture at a tax deed sale, maybe if you didn't get notice of the sale itself, there may be a surplus, just like a foreclosure action. There may be a surplus at the sale. There may be a surplus at the tax deed sale as well. So if that does exist, then you have 120 days to file a claim, and the court may have an evidentiary hearing to determine the priority of the claimants if there are competing claims. There typically does involve a surplus, but it will typically not be enough to recoup the potential interest that was lost in the first place, at least not for all cases. So it's really important. I can't stress it enough. All right, and this is our contact information. So if any of you ever have any questions, feel free to reach out to us, both Mitch Barry and myself. again, even if it's not a Florida or Arkansas and it relates to another state, feel free to reach out to us and we can make sure that you get that information as quickly as possible.
Hey, Steve, I thought of something that I failed to address, which is what are the necessary documents needed from our client to start the foreclosure or the Replevin action? And that's going to be a copy of the contract or the note, and also a copy of the certificate of title with the lien noted on it. There are going to be instances in Arkansas where you don't have a certificate of title because it has been surrendered to the state to make the home part of the real estate. If that's the case, instead of the certificate of title, we would need the document that you receive back from the state that says the title has been surrendered. So really it's two things, the note and the certificate of title, or evidence that's been surrendered.
Yep, that's a great point. And in addition to those documents, the documents that we also would request, if the security instrument or note requires a demand letter to be sent, then we would need a copy of the demand letter. Any updated figures or updated payment history will be helpful as well to determine the outstanding balance. But yes, the security instrument, the certificate, updated certificate of title, those are the most important documents. All right, next we're going into questions. So we have had a few questions submitted. Once again, the questions tab, feel free to ask away any questions that you may have and we can help answer. And if you think of it later after the webinar, feel free to ask any additional questions directly to Mitch and myself and we can assist you. Mitch, this first question goes more to you. Do the borrowers have to be named as defendants in the Replevin action even when they are no longer living in the mobile home?
Okay, you want me to give that one a try, Steve?
Sure, go ahead.
So really it's not always necessary that the borrowers be named as defendants in a Replevin action. Obviously, if the borrower or borrowers are deceased, you're going to name the heirs. There could be other situations, like a landlord-tenant situation where the borrower doesn't live in the home and is instead leasing the home out. In that case, you're going to need to name whoever the tenant is in your Replevin action. Basically, it's whoever is in possession of the home, whoever lives there, or whoever is exercising control over it, which could be a mobile home park landlord that is exercising control over that home. So it can vary depending on the facts of the case, and the facts can develop throughout the case as we try to get service and things of that nature.
Great. This next question, actually, I'll take it. It relates to order to show cause. Great question. For order to show cause hearings on a mobile home, do courts typically delay issuance of writs and allow the borrower time to move out? If so, how much time is given? It really is going to depend on the judge and the circumstances raised by the borrower at the hearing. Typically, courts are a little bit more lenient with time if the borrowers are still living in the property, so they do give them some extra time. Some judges, if no defenses are raised, will direct immediate issuance of writs, and there is a little bit of a delay between getting those writs over to the sheriff. Not on our end, we provide them to the sheriff immediately upon receipt. Sometimes the sheriff is delayed with going out to the property, and that's a little bit outside of our control. But that's typically the process in Florida. Courts will sometimes give up to a week or maybe even 30 days, depending on the circumstances and if there's children involved and whatnot. So courts typically, if the borrowers pull at the heartstrings a little bit, they're a little bit more lenient, but we don't see too many long, extensive delays. All right, that was a great question. And we actually have another question. Mitch, I'll let you take this one. It says, what do you do about landlords who will not surrender possession of the home until they are paid a lot rent?
Okay, that's an issue that we run into fairly frequently in Arkansas. Is a mobile home park landlord or just someone who, whether it's a family member or an actual landlord that allowed someone to park a mobile home on their property. They'll respond to our Replevin complaint and say, hey, you owe us before you can come get this home. The the lot rent is something exorbitant, like $500 a month to park this home here, and you owe us for the last 3 years, and you can't come get this home until then. Well, there are a number of defenses to that. First of all, we did not make any sort of agreement. The servicer did not make any sort of agreement with that landlord to pay lot rent. That was, if there was an agreement, that was between the landlord and the borrower, or whoever the occupant of the home was. That doesn't involve our client at all. Now, a lot of times landlords will try to say, well, that's a lien on the property. We have a landlord's lien on the property, and there is a statute in Arkansas for a landlord's lien to attach to that property. But in order for them to perfect that lien and make it enforceable, they have to give certain notices to the lender, to the servicer, before that becomes a lien. And I have never seen a mobile home landlord follow the statute and do that properly. So generally, we can work our way out of that. If we end up in front of the court is not going to recognize the lien, and normally we can get those resolved with some sort of settlement where we pay them just a little bit of money, promise not to tear up their property, and when we pick up the home and things of that nature. But normally there are ways to resolve it. If we do end up in court on an issue like that, we feel good that we can beat that claim.
Okay, great. I see two more questions. I can take this next one. How long does it take the sheriff's office to serve the writs after they receive it? Like the previous question that I answered, it is going to vary on the county and on the specific sheriff's department and how busy they are and how quickly they do get out. PLG really prides itself on having a strong relationship with sheriff's offices across the board. We work with them consistently on a lot of files. They know us. They respond quickly to us. So we pride ourselves on maybe beating other firms' timelines as far as being able to communicate well with the sheriff's office and get them to go out as quickly as possible. But again, it is going to vary by the county and by the sheriff's department and how busy they are at that time as well.
That would be the same for Arkansas.
All right. And the next question is, what's the average timeline for Arkansas and Florida to complete a Replevin? Mitch, you want to take Arkansas first, and then I'll take Florida?
Sure. Of course, I'm going to weasel out of a direct answer and say it varies. It depends on the circumstances, which it does. If we have a perfect file where we have all the documents in line and we know who lives in the home and we're able to get service on them quickly, we can get an order for delivery, in roughly 30 to 45 days is possible. Typically, there's going to be a bump in the road with service or something of that nature, and I'm going to say 60 to 90 days is more typical, maybe even 120 days in some cases.
As far as Florida, it's similar with the order to show cause statute if we're proceeding in that manner. Most of the time, what we're waiting on is the court to sign and execute the actual order to show cause. So a lot of times we're following up multiple times to get the order entered. We submit it right away upon filing, but sometimes the court is a bit delayed. And like Mitch said, in a perfect world with a judge that executes the order to show cause immediately upon receipt or close to immediately upon receipt, 30 days is probably a perfect world, but we do see roughly 60, sometimes 90 days. But again, the delay is not on our part, because in Florida, you don't have to verify the complaint like you do in foreclosure. So the Replevin timeline does beat the foreclosure timeline, but 60 to 90 days based on court and sheriff delays is typically what we see.
Same here, Steve. We have a lot of courts, judges that sit on these orders and just don't sign them, and we have to call and call and call.
Okay, great. I think that's the last question that I see. Thank you again for joining today's webinar hosted by Padgett Law Group. A shareable recording of the presentation, a PDF of our materials, and a certificate of attendance will be made available to all registrants shortly. Additionally, in that email, you can register for our next webinar covering Chapter 11 bankruptcies, and that's on June 25th at 2 p.m. Eastern Time. But this concludes today's presentation. Thank you all for joining, and have a great day.
Thank you.